Mallard.
Thank you. This is Kelsey Wazolinki from Jost Energy Law on behalf of Mallard Exploration, LLC. I'd like to start our case today just by giving you a brief overview of what Mallard's application is requesting. I apologize if these slides are a little bit small. You do have a printout of your PowerPoint in front of you if it's easier to read. So Mallard is seeking to vacate an undeveloped 1920-acre unit established for Sections 1 and 12, Township 8 North, Range 60 West, and Section 36, Township 9 North, Range 60 West, to vacate an undeveloped 320-acre unit established for the west half of Section 31, 9 North, 59 West, to approve a 960-acre drilling and spacing unit for the west half of Section 31, 9 North, 59 West, and all of Section 36, 9 North, 60 West for efficient, economic, and imminent development of the Codell, Niobrara, Fort Hays, and Carlisle formations, to approve 16 new horizontal wells, 12 of which will target the Niobrara formation, 4 of which will target the Codell formation. The Fort Hays and the Carlisle are non-target formations, but because we're outside of GWA, they are not considered common source and therefore included in the application. To approve 600-foot boundary setbacks and 150-foot interwell setbacks. And finally, to approve no more than 2 new well pads within or adjacent to the unit. So this is Mallard's Exhibit 1, which is Bates number 22. This shows the box of the 960-acre unit in black. Mallard filed this application on November 30th, 2017. Mallard then filed 12 APDs, which are currently in process. Those were filed on December 22nd and 27th, 2017. And as you can see in this map, Mallard is currently developing 16 approved permits in the approved unit adjacent to the east of these lands. They're shown in green. You can hardly see them on the screen, but they are 16 approved wells. And as you can also see, Mallard is proposing to share all of the surface locations with the approved unit adjacent to the east. So when you are evaluating whether to approve Mallard's application today, there are a few important themes that I want you to consider. First, efficient and economic development. Mallard's proposed unit provides the most efficient and economic recovery of the hydrocarbon resource underlying irregular section line boundaries. And I'd like to point you to, this is Verdad's Exhibit E, which is Bates number 342. It shows the irregular section lines in the unit adjacent to the south, which Verdad claims it intends to develop and in which Mallard is seeking to vacate. There's about 550 feet of gap in between those section lines. And Mallard, on the other hand, is proposing to develop in an east-west lateral orientation, which completely eliminates the wasted hydrocarbon resource with those irregular section line boundaries. Mallard's proposed unit also reduces surface waste. Mallard is proposing less pad locations and shared pad locations with the approved unit to the east. And as evidenced by Verdad's own filed APDs to the south of the application lands, Verdad's leasehold in sections 1 and 12 can be developed through 2-mile laterals to avoid mineral waste. Second, I'd like you to consider intent to develop. Neither Verdad nor its predecessor have developed its leasehold interest since it was first acquired several years ago, and the 1920-acre unit was first established in 2015. It was only after Mallard filed its APDs in December of 2017 did Verdad attempt to file overlapping APDs to develop its leasehold interest nearly 3 months later. Further, Mallard's application is more complete in requesting to space the Carlisle and Fort Hays formations outside of GWA. The 1920-acre unit that Mallard is seeking to vacate, in which Verdad claims it intends to develop, is only spaced to the Codell and Niobrara formations. Third, the existence of communitization agreements is simply not relevant to the approval of a drilling and spacing unit application. Verdad will likely introduce evidence of state and federal leasehold and communitization agreements that's just not relevant to the question of whether Mallard's application complies with the Act and will result in the efficient and economic development of the hydrocarbon resources while minimizing waste and protecting correlative rights. As we will demonstrate today, Mallard has agreed to submit state and federal communitization agreements to the State Land Board and the BLM prior to development of its unit, should the unit be approved. And I'd also like to note that the BLM did initially protest Mallard's application. The protest was based on a communitization agreement that was applied to the 1920-acre unit, which Mallard is seeking to vacate. The BLM ultimately withdrew its protest after finding that that CA had expired. So the testimony that we will introduce highlights several important factors that support the approval of Mallard's drilling and spacing unit today. We will provide substantial evidence that Mallard's proposed well configuration within its proposed unit presents the most efficient and economic development of not only the subject unit, but the surrounding lands as well, when you consider the irregular section line boundaries and the ability to share surface locations and pipeline infrastructure. Furthermore, we will prove with substantial evidence that Verdad has failed to support its protest in this matter. Thank you.
Good afternoon, Commissioners, Director, and staff. The good news is no discussion on pooling. So thank you very much for your time today. I'm Michael Jewell with the law firm of Burns, Figa, and Will on behalf of Verdad Resources, LLC. Today you have a case before you we believe should strike some suspicion in your minds. It challenges the presumptions of your rules and I hope will compel action for you to deny this request, this application, and preserve the dignity and solemnity of your orders. An APD is not the only litmus test for development. As you all well know, or one can reasonably suspect, much more goes on in the planning and development to drill and to operate correctly. This sounds intense, but consider Mallard's application asks you to defeat 2 sets of orders, orders that this body reviewed and you approved based on science and trends in the basin. Yet, I don't think you'll hear anything new about new science, new orders, or even new policy or trends that would defend Mallard's application and obliterate these 2 sets of orders. They were delicately and diligently prosecuted over a number of years, as you will see, and create a new DSU for nothing more than an acreage lockdown. You see, the lands we're looking at, which we will call Sonic Star a lot, is the vertical DSU that exists now, is not a run-of-the-mill DSU. The lands are already covered by existing orders. They present important needs. That is, the lands are owned by the federal government through the BLM, the state of Colorado, as administered by the State Land Board. More than that, on the federal lands, these cover the Pawnee National Grassland, which is a sensitive and important environmental habitat, which requires the federal lease over those lands to have an NSO, no surface occupancy stipulation. So as you can imagine, it makes it a little more difficult to find offset pads, for which my client has procured. Took some time to do this properly to get the right SUA of the State Land Board and adjacent landowners to get these lands locked down so that that environment is not disturbed and is properly developed. Verdad and his predecessor worked carefully with the State Land Board for those agreements. Verdad and his predecessor procured CAs, indeed, not only from the BLM, from the State Land Board. Admittedly, the first communization agreement expired, but was renewed by the BLM in July of this year. But you'll see that Mallard comes into this application, at the date of its application, according to our title, owned 5% of the lands of the proposed DSU. My client, on the other hand, owns, through its partners, 100% of the current Sonic Star unit. And even if this application were to be approved, would still be the majority owner of the new DSU at over 2/3. Granted, you don't have a rule that says you have to have a minimum percentage, but I think it sort of strikes some doubt about the reasonableness of what is happening here. Not only that, this application filed November 30th, 2017 was right at 6 months. 6 months after you approve Sonic Star. So again, there's not a rule that says how long a DSU order would remain over the lands, but let's consider one good waypoint, an APD. Your APDs last 2 years. So this is 1/4 of the time that an operator is given to develop and consider drilling off an APD that you're being asked to terminate something you already approved. This necessarily calls reasonableness into play, especially when you demand things to be done right, and Verdad insists on doing the same. So my client is indeed ready to drill, but it did its homework. My predecessor started the ball rolling maybe 2 years ago, getting all these agreements, getting the leases, getting everything done properly. Verdad purchases the asset. Verdad gets the permits filed within a week or so that they are allowed to do so by the commission. Verdad will explain to you about the permits it's filed and how once you hopefully reject this application, it will move in haste to see that these federal and state leases the environment that respects the SUAs and the economic drilling will be seen through completion. We do need to start drilling pretty soon because the state lease over 36 will expire relatively soon. But a lot of the groundwork that my client conducted had to get done before we could drill. And lastly, to that point, we do have midstream contracts where all fluids will be piped out. There will be no trucking, so the impact will be mitigated. So in summary, two things to keep in mind. Number one, by rejecting Mallard's application, this means that this commission will promote administrative certainty. Rules and orders are not temporary plastic stakes in the ground ready to be plucked away for unfairly gained advantage. Secondly, this commission stands for a culture of hastiness and rush will not be tolerated. You want things to be developed right. Filing an APD is not prima facie development. Much more goes into it than that. So please keep those two concepts in mind as we move forward today. And thank you for your time.
Thank you. May I begin with our first witness?
Should we go ahead and swear all the witnesses in at once to facilitate keeping this thing moving?
Would proposed witnesses for both parties please all stand, and we'll do this all at the same time. Start with the gentleman on my left here. If you just raise your right hand, state your name, and then say that you swear to tell the truth, and we'll work to my right.
My name is Matt Volkmar, and I swear.
Thank you.
My name is Jordan Madsen, I swear to tell the truth. My name is Arthur Beach, I swear to tell the truth. My name is Frederick Grove, I swear to tell the truth.
All right. Thank you.
Thank you. Ms. Prine, just as a quick procedural matter, would you mind letting us know when we have 5 minutes remaining? Thank you. So I'd like to introduce our first land witness, Mr. Jordan Madsen. Mr. Madsen, can you please provide your name, a brief summary of your background, and your position with Mallard?
Thank you. My name is Jordan Madsen. I graduated from Western State Colorado University with a degree in professional land and resource management. I'm a certified professional landman via the AAPL. I've been employed in the oil and gas industry for approximately 10 years. I currently serve as Vice President of Land for Mallard Exploration.
Thank you. And are you familiar with Mallard's application today?
Yes.
And are you familiar with Verdad's protest to Mallard's application?
Yes.
And did you prepare land exhibits 3 through 7?
Yes.
Thank you. I'd like you to briefly walk through your land exhibits for the commissioners today. We'll start with exhibit number 3, which is Bates number 75. Can you please describe Mallard's leasehold ownership within the application land?
Yes. Obviously, a projector is quite small, so I'll kind of run through these the exhibits in front of you. So this is Bates number 75. As you can see on the exhibits, Mallard's leasehold is shown in yellow. Mallard owns 96.5 net mineral acres and approximately 240 gross acres. I'd like to remind everyone that development of the state's mineral interest in Section 36 will benefit Colorado public schools and institutions as well.
Thank you. And turning next to exhibit 4, which is Bates number 76, can you please describe the mineral ownership within the application lands?
Yes, this exhibit depicts surface ownership of the application lands. Fee surface lands are shown in yellow, bed surface in green, and state, which is Section 36, is shown in white within the application lands.
Thank you. And just to clarify, did you mean mineral ownership? I believe you said surface.
Excuse me, I'm sorry, I meant mineral ownership.
Thank you. And does Mallard have any communitization agreements for its proposed development?
Mallard and the State Land Board have agreed to the following language. A communitization agreement must be submitted prior to drilling operations for a well within the drilling and spacing unit. Accordingly, Mallard will agree to submit a CA to the BLM prior to drilling operations for a well.
Thank you. Turning next to exhibit 5, which is Bates number 77, can you please describe the setbacks requested by Mallard for its proposed development?
Yes, pursuant to Rule 318A, Mallard submitted application for 600-foot boundary setbacks. These 600-foot setbacks are represented by the dark line on this exhibit. Mallard is supportive of reduced setbacks if the spacing unit is approved and has been actively working with interest owners in the vicinity of the application lands on reduced setbacks related to similar spacing units.
Thank you. Turning now to exhibit 6, which is Bates number 78, can you please describe the surface ownership of the application lands?
Yes. Yes, the surface applications in the application are state and fee.
Thank you. And does Mallard have a surface use agreement to develop the 16 wells within the proposed unit?
Yes, Mallard has a surface use agreement with the surface owner in section 31 for a total of 4 well pads. Mallard is currently using 2 well pads for the drilling of the Shaw East wells, which are just in the vicinity to the east and adjacent to this application. And we will share the total of 4 well pads between both units to reduce surface waste.
Thank you. And can you please describe the pipeline and infrastructure that is in place to develop the unit adjacent to the east of the application lands?
Yes, currently in place, there are 2 pad locations, access roads, flow lines, gathering lines, electric lines, and production facilities, all of which service Mallard's ongoing development of the Shaw East unit, and also would support development of the application lands. The northernmost pad that you see on the exhibit contains producing horizontal wells, and the southernmost location contains production facilities. The remaining infrastructure connects generally those 2 pad locations.
Thank you. Turning next to exhibit number 7, which is Bates number 79. Can you please briefly describe the topography of the application lands?
Mallard worked with the surface owner in section 31 to locate the best surface locations considering the topography of this area.
Thank you. I'd like to direct you next to a map of the commission website. We are using this exhibit as a demonstrative exhibit showing the status of all APDs filed within and around the application lands, and this is current as of today's date. Mr. Madsen, can you please walk us and the commissioners through the timing of Mallard's application and the subsequent APD filings by Mallard?
Mallard's application was filed on November 30th, 2017. The 12 APDs filed for the Shaw wells were filed on December 22nd and December 27th of 2017. Surface locations are shared with the approved APDs to the east in an approved drilling and spacing unit to prevent waste.
Thank you. And are you aware of the APDs filed by Verdad in and adjacent to the application lands?
Yes.
And can you please describe Verdad's APDs filed in and adjacent to the application lands?
Verdad filed 16 Sonic Star APDs to develop sections 1 and 12 of Township 8 North, Range 60 West, nearly 3 months after Mallard filed the APDs for Shaw East. The date of Verdad's application was March 9th, 2018. I'm going to point out on the projector here, just for everyone's reference, the Sonic Stars are those wells that were located in section 12, or I guess beginning in section 12, drilling up to the north. 2 of those wells are 2-mile laterals, which evidence that 2-mile wells can be developed. And then the additional wells, which will be in there, are the Peggies, which were proposed to be drilled from the north down to the south, abutting the Sonic Stars. And then finally, the Potasniks, which were planned to be drilled in the west half of section 31.
And can you please describe for the commissioners why those Potasnik and Peggy APDs are not shown on the commission website?
They were rejected due to Mallard's filed APDs.
Thank you. This next slide depicts the APDs that are actually in your portfolios as exhibit number 2. These are Bates numbers 23 to 74. And Mr. Madsen, pursuant to your prior testimony, can you please confirm that these are the 12 Shoal APDs that have been submitted by Mallard for development of the application lands?
Yes, that's correct.
Thank you. And are you aware of the leasehold ownership of Verdad and its predecessor in title within and adjacent to the application lands?
Yes.
And can you please describe that leasehold ownership?
Yes, the BLM lease covers section 1 and 12 of 8 North 60 West. Lease was effective March 1st of 2010. It was subsequently assigned to Carrizo in October of 2013, and then finally to Verdad. As of today, there has been no development within these lands. The state lease, which encompasses all of section 36, 9 North 60 West, the lease was effective August 21st, 2014. It was assigned to Carrizo in October of 2014 and subsequently to Verdad. And there has been no development within these lands to date.
Thank you. And my last question for you, have you attempted to resolve Verdad's protest prior to this hearing?
Yes, we have. beginning as early as March of this year, various Mallard staff had scheduled in-person meetings to discuss resolution to the matters at hand. Several of those proposals received positive feedback in person, but no definitive follow-up response from Verdad or counter proposal. All of Mallard's attempts to resolve this matter were unsuccessful.
Thank you. And since there have been no objections or evidentiary motions, I would move to submit all of Mallard's land exhibits into the record. Next, I'd like to move on to geology. As Mr. Rouse indicated, the parties have stipulated to all of Mallard's geology exhibits submitted in support of its application today. This slide depicts all of the Mallard geology exhibits that are undisputed. Those are in your portfolios, Bates numbers 80 through 89, exhibit numbers 8 through 17. I'd like to just briefly walk you through a few of the highlights of the stipulated geology facts. It is undisputed that the Niobrara Formation is present throughout the application lands, and it is approximately 300 feet thick. The Fort Hayes Formation is present throughout the application lands and is approximately 24 feet thick. The Codell Formation is present throughout the application lands and is approximately 9 feet thick. And the Carlisle Formation is present throughout the application lands and is approximately 20 feet thick. And Mr. Volkmar, who will be our next witness, is available if you have any questions on the geology stipulated facts today. So I would like to introduce our next witness. Mr. Volkmar, can you please just provide your name, a brief summary of your background and your position with Mallard?
My name is Matt Volkmar. I'm the president of Mallard. I'm a petroleum engineer by background and a registered professional engineer in the state of Colorado since 2012, and have roughly 10 years of experience dating back to Kerr-McGee in the DJ Basin.
Thank you. And did you prepare engineering exhibit numbers 18 through 21 submitted in support of Mallard's application today?
Yes.
Thank you. I'm going to have you briefly walk through your exhibits for the commissioners. We'll start with exhibit number 18. Thank you. Which is Bates number 90. Can you please describe your Niobrara and Codell volumetric calculations?
So exhibit E1 here is Niobrara and Codell volumetric calculations. This is common oil in place formula here with associated input variables that come out of the geologic testimony. And these variables have been pulled from extensive petrophysical analysis from core, from open hole log derivations, from direct fluid measurements when we have it, and indirect correlations if we don't, and lots of available public data in the area. So you can see there's a 1 mile and 2 mile well analysis here, various projected type curves and ultimate unit recovery factors, which are the same for a 1 mile versus 2 mile well scenario, just because we're looking at the same number of wells per section.
Thank you. Can you just describe why these recovery factors are important for the commissioners to understand?
We analyze the optimum development by looking at the number of wells per section and trying to eliminate any overlap of drainage, because that's kind of the biggest detriment to well performance is if wells are competing for the same resource. So again, what we're trying to optimize here is wells per section. And what's important is that the DSU requests up to totals of 16 wells, and this is a scenario for 12 in the Niobrara and 4 in the Codell, but there's flexibility as we gather more data, as we get new wells, to kind of adjust those numbers slightly if the numbers dictate that we should.
Thank you. I'd like to turn next to exhibit number 19, which is Bates number 91. Can you please describe your analog well evaluations?
Yes. So this is an analog well evaluation of several representative wells in the surrounding area in both the Niobrara and the Codell. There are several more Niobrara wells here just because the number of Codell wells in the area is limited. This is all of them. And basically what we're looking for here is analog wells that are geologically representative, that have consistent production history, and that were executed by a prudent operator standard. So when you kind of average the results here through the calculations of the drained acres that you can see below, we get an average drainage radius, average drained acres in the Niobrara of 37 and in the Codell of 159.
Thank you. And why is this drainage analysis important for the commissioners to understand?
as I kind of touched on in the last exhibit, we're trying to avoid overlap of drainage of wells. And if you'll notice, the second Niobrara well here, which is the highest drained acres, is 52 acres. So if you back calculate how many wells per section you could put in that case, that would be just 12 wells per section. So like I said, we're trying to avoid any overlap of drainage among these wells.
Thank you. I'd like to turn next to exhibit number 20, Bates number 92. Can you please describe the analog well location map?
So this shows all active horizontal wells in the area and stars representing the analog wells which surround the unit. As you can see, the Codell wells, as I mentioned before, are limited and off to the northeast of the unit, but we used what we had in the area.
Thank you. And finally, exhibit number 21, Bates number 93. Can you please describe your decline curve analysis?
This exhibit here is a representative decline curve analysis, basically rate and time, that we've used a history match over 500 wells in the area to predict the ultimate recovery that you saw in the previous exhibit. And ultimately, this is industry accepted, and resulting B factors, which is the rate of decline and how it changes, are 0.9 to 1.3. Initial decline, DE, is 50 to 90%. Terminal decline, which we run out until the wells reach economic limit, is at 8%.
Thank you. And based on your engineering analysis, are the 16 wells proposed by Mallard in the 960-acre unit economic?
Yes, and we have drilled 2 wells just this February with the most recent costs and commodity price environment that prove that we have economic wells.
Thank you. And can you clarify where those wells were drilled?
Immediately east of
Thank
the DSU in question.
Thank you. Isn't it your opinion that the proposed 960-acre unit for the development of up to 16 wells in the Codell and Niobrara target formations is the appropriate size, will prevent waste, and allow for efficient and economic development of the minerals?
Yes.
And have you reviewed Verdad's economics and engineering exhibits submitted in support of Verdad's protest?
Yes, I have.
Thank you. Can you please discuss your analysis of Verdad's engineering exhibits for the commissioners?
Yes. So if you've also reviewed the extensive testimony here, Verdad has included its own testimony as well as testimony from the previous 2 exhibits from Carrizo before this. And if you put all this testimony together, there's a lot of inconsistency among it. There's definitely some errors, one which I'll kind of walk through here in a minute. And there's a few tools that are pretty obsolete for unconventional well analysis that I just want to talk through as well. So I referenced several Bates numbers here that you can kind of refer to in your own time, but just looking through all this testimony, you can see different water saturations and various pages of this testimony, and ranges from 14% to 77%. Well, that's a huge metric that kind of impacts how much oil's in place and how all your volumetric works. These aren't like a close range. I mean, this is drastically different. Verdad has claimed multiple cases where they have evidence that frac radii don't extend past 300 feet, hence why they've requested, or they're trying to justify 300-foot radii. Yet in their own testimony, they've submitted in Bates 423, there's effective radii that expand well beyond 300 feet. And just looking at the theme of all these different testimonies, there's justification for 16 wells a section, 32 and 48. So there's just this wide swath of testimony that's kind of been pushed through with no real conclusion, just a lot of data.
Thank you. I'd like to direct you to Verdad's Exhibit B, which is Bates number 303. Could you please summarize your impression of this testimony?
Yes. So you'll notice this exhibit here. There's a lot of data, but there's one number that really stuck out, and I've kind of highlighted it here. It's Verdad's calculation.
Commissioner Ben, we object to this. This is geological testimony. This is geologic testimony. This is an engineer witness.
May I respond?
Yes, you may.
This is an engineer's analysis using a stipulated geological fact. This is not geology testimony.
I'll overrule the objection.
So on this horizontal well EUR and drainage estimate spreadsheet here, the calculated number that is used is a FEH number of 5.5 in the Codell. Well, we've accepted that the Codell here is 9 feet thick, and FEH is a calculation of net thickness times porosity, which is basically like the meat of your reservoir. So 9 feet thick times 15% porosity is 1.35. So they've overestimated the FEH by almost 4 times with their number of 5.5. And if you run through all the calculations here, To get the drainage radius, you're actually getting a drainage radius of over 1,500 feet based on their number. So again, kind of a major error that really is counter-conclusive to the conclusions that they're trying to draw in their testimony. And just wanted to point that out as well.
Thank you. I'd like to turn next to Verdad's Exhibit H, which is Bates numbers 421 and 474. Can you please also provide your impression of this exhibit?
So these two exhibits are exhibits also used to justify the reduced setbacks. First plot is an RTA plot. It's not very legible, but should have rate, pressure, time as an RTA plot does. But ultimately, there is just a conclusion here that the drainage radius is 140 feet, which I would like to know how they got there. Also, this Bringleson well in the location reference, section 28 north, 858 west, doesn't exist at that location. It's probably just a typo, but again, just kind of a error or sloppy work, or maybe the well doesn't exist, I'm not sure. And then the second exhibit here, the frac model. Today's horizontal wells are infinitely complex with multi-stage fracs through different rock, different layers. And this frac model here appears to be Frac Pro 2D, really doesn't bring in all the complexities of the horizontal wells and what we're doing today. So it's a bit of an obsolete analysis. And again, it's kind of counter-conclusive to what they're trying to draw here.
Thank you. And finally, I would just like you to summarize your engineering testimony for the commissioners today.
So we believe Mallard's proposed development will optimize recovery from the reservoir in the Codell Niobrara while preventing waste and protecting correlative rights. Our calculated EURs and drainages are derived from a lot of extensive background work that you don't see here, but you see the consensus summary of it. And ultimately, our development plan is placed to prevent interference between the wells, because as we have seen, that's the most detrimental impact to well performance, economics, and ultimately waste on the well. So we believe our DSU as planned will optimize the development of the reservoir here.
Thank you. Since there have been no objections or evidentiary motions to Mallard's engineering exhibits, we would request that they be entered into the record.
Very well.
Thank you. That concludes our case in chief.
Very well. Any cross-examination? Mr. Jewell?
Yes, sir. Thank you. I could have Mr. Madsen back, please.
Yeah.
Mr. Madsen, you mentioned discussions with the state land board, and if I could summarize, language that you would agree to put into your CAs and other agreements with them. It sounds, you've dealt with the state land board numerous times, I'm sure, your position or a similar position.
Correct.
And would you characterize this language as typical?
For the staging of the proceedings that we are in, I would say yes, it's typical.
At the time of your application on November 30th, you were aware of the existing orders in these two DSUs that are currently on the books, right?
We were.
And you were aware that the Sonic Star, or the so-called Sonic Star unit, was approved in May 2017.
Yes.
That's a factual question. It's just that's 6 months from your application from the date of Sonic Star.
I'd just like to clarify for the record, that is an inaccurate statement. It was approved in 2015 and amended in 2017.
Well, the last time it was approved was 2017.
The unit was established in 2015 and amended to add the Codell formation in 2017. I think it's an important distinguishing fact.
And so then, Mr. Madsen, would you agree that adding the appropriate formations would be developing a unit?
Not necessarily, no. I don't deem that as action.
What contracts, do you have any contracts in place for pipelining?
For pipeline?
Yes.
Yes, we have a wide sweeping agreement with a midstream provider to move our products. Immediately in the vicinity of this unit, we have an agreement with Noble, or MBLX technically, which is taking our gas from the adjacent facility.
And so just to be clear, that agreement that you're referring to would cover this proposed unit immediately?
Yes.
Would you have to do any trucking in the interim?
In the interim, when would you propose that we would develop this? I mean, it's kind of a logistics question as far as timing.
Well, we're just trying to understand. We're not aware of, in in the record title or anything of any gas contract or purchasing agreements. We're just trying to clarify.
Happy to show it to you.
Okay. Yep.
There's a memorandum filed of record.
And your agreement covers liquids as well, correct?
The agreement covers liquids, gas products, and there's only a memorandum filed of record. So of public knowledge, there's proprietary terms in our agreement.
Do you know what percentage of the leasehold you own in the proposed DSU?
I believe it's approximately 10%.
Does that include disputed amounts, or is that free and clear?
In my opinion, it is free and clear.
To your knowledge, are there any disputes of title? Is that 10%?
We have had some dispute with Verdad specifically over a lease with Mike and Peggy Shull or Shull Interests, yes.
And that dispute is ongoing.
That was part of our discussions, which I don't want to get into the details of those discussions, but yes, we have been discussing that lease.
And have you done any APD scoping with the BLM at this point in time?
We are approaching the BLM in more of a regional view, I guess. So we're talking to them about more of a comprehensive development plan and not focusing just on one unit or another, but in an effort not to waste the BLM's time, our time, or any regulatory body, we're not pursuing permits for units which we do not have a state approval for.
And I'm glad you mentioned comprehensive development plans, but you have not filed, just to be clear, a CDP under the state rules that cover this land, correct?
No, not by that definition, excuse me.
Are you aware of what level of ARC survey you would have to conduct with the BLM?
Regulatory is not my specialty, but no, I'm not familiar.
So at this point, any discussions with the BLM are probably classified as introductory.
I wouldn't say that. We have a number of ongoing matters that we discuss regularly with the BLM.
No further questions, Mr. Madsen.
Thank you.
Have a
Any
quick
redirect?
Redirect, yes.
Yes, you may.
Mr. Madsen, I know you went over this in your land testimony today, but can you please remind the commissioners the federal minerals located within the proposed unit, where exactly those are and how many acres they encompass?
Yes. Bear with me one moment here. The federal minerals encompass 80 acres of the proposed 960 acre unit.
Thank you. And do you have any ARC surveys to the east of the application lands?
To the best of my knowledge, yes.
Thank you.
Thank you, Mr. Madsen. Mr. Volkmar, please.
Thank you.
Volkmar, sorry. Mr. Volkmar, did Mallard conduct any rate transient analysis to refute the existing DSUs?
No, we have not.
You described the testimony for the creation of at least the Sonic Star unit as being somewhat counterintuitive or even obsolete. Yet, at the time of the original application in 2015 and then the adding of the Codell in 2017, would it have been reasonably accurate?
What's the question?
Sure. You said I'm paraphrasing, I suppose, that the engineering analysis for Sonic Star was either counterintuitive or obsolete, were the words you used. However, at the time the original application was filed 2015, 3 years ago, would it have been reasonably accurate?
There were still elements that were conclusive. Basically, some of the Carrizo testimony I highlighted at that time showed frac radii that were longer than the setbacks they're requesting. And a 2D frac model was known to be obsolete probably when unconventional started over 10 years ago. So elements of it were still inconclusive and inconsistent.
No further questions.
All right. Commissioners, any questions? I'm sorry. Okay, we'll give you a few minutes. It won't count against either of you. Well, We stew over this just a bit.
Mr. Chair, I have a quick one.
Yes, Commissioner Egger.
What's the difference in the colors of the wells? The blue and the green primarily?
So the green are approved permits, and the blue are pending permits.
Yep, Commissioner Hawkins.
I just want to make sure I understand your analysis of the drainage areas and so I'm kind of going to walk through this just a little bit. So the original oil in place calculations are pretty straightforward, and the EUR is estimated from your decline curve analysis of analog wells.
Correct.
And then looking at your EUR, you have to take I guess an estimated frac length area or dimension in order to calculate what the total acreage drained is going to be.
Correct. You basically have the size of your tank by height and
Right.
width and the
And so
saturation.
what do you come up with for your frac length analysis? I'm just like, it's probably on here and I just didn't,
So ultimately, the way that
the
we,
lateral length.
so that there's no specific frac radii here. Ultimately, the way we are analyzing it is by the size of the unit and the number of acres that are drained. And so everything here is normalized on a 640 basis, so 1 mile wells. And so what we are trying to do is prevent any overlapping drainage areas of these wells. So basically, you know, the max case scenario here was 52 drained acres. So assuming the wells have uniform drainage and they're spaced appropriately across, you know, a 640 basis, they're spaced in a sense evenly so that there's no overlapping drainage. I didn't calculate a specific radii here, but that's kind of how we approach this versus looking at a frac radii, just because kind of that methodology of, you know, 20 to 40 to 60 multi-stage fracs along the lateral with different geologic complexity and faulting and fracturing, like to say that this is a frac radius and this is consistent across a mile well is not good engineering in my opinion.
Yeah, I was just trying to compare what your analysis, your with what Verdad has, their frac widths range 500 to 700 feet, and there's an effective frac radii of 200 to 400 feet. In your analysis, it's 200 to 400 feet. Is that correct or not?
On average, yes. I can see scenarios where it exceeds that as well. But yeah, based on these results, that's probably a rough approximation.
And did I hear you say that you will, maybe it wasn't you, it might have been the land department it says there's agreements in place to remove produced water or water from this and through pipeline, or?
Correct. Yes, we are under contract with a third-party midstream group to move all liquids off location through pipe. So water would be included in that, straight to a disposal facility.
All right. Thank you.
Commissioner McGowan.
I probably have very stupid, simple questions. Sorry. So in the beginning of your presentation, you were talking about, I think what you're saying is that your proposal is going to extract more minerals than Verdad's. I think that's what you're saying. But then you also say that their communitization agreements, which I had to look up, are irrelevant, but that implies that they've worked with others to try to develop a cooperative agreement for drilling. So have you all tried to develop a cooperative agreement? I'm just trying to parse this out here.
Yes, and if I may answer that question, I think there's a couple factors at issue here. When you're seeking to approve a drilling and spacing unit, you have to decide if that unit complies with the mandates of the Oil and Gas Act. Does it prevent waste? Does it protect correlative rights, result in efficient and economic development? And so part of our testimony today is proving that yes, it does. The evidence of communitization agreements is not a relevant factor in approving a drilling and spacing unit agreement. That being said, Mallard is actively working with those two, the federal agency and the state agency, to have a CA in place. They're just waiting on this unit to be approved, and they will have a CA in place and commit to that prior to the wells being drilled.
So all things being equal, let's just assume that both parties, I know you're arguing that you're not, but let's assume that you both are extracting to the best of everyone's ability all the mineral rights and protecting everyone's water rights. In your estimation, who has a plan that's going to be most protective of what you have described, I think, as some protective grasslands there?
And I believe what you're referring to is for Dad's opening statement, there's the protective grasslands over a certain surface location that they're proposing for their development of their 1920 acre unit. That's not an issue for Mallard. Mallard has a surface use agreement with a fee surface owner in section 31 for up to 4 pad locations, 2 of which have already been built.
Okay, thank you.
May I ask a question, Mr. Chair?
Certainly, Commissioner Overturf.
So this commission has had a number of circumstances where, and perhaps this is better addressed to you as the attorney, has had a number of circumstances where we've had competing spacing units that have been filed simultaneously or nearly simultaneously. This is different in that there's an approved spacing order already in place, and you are asking the commission to undo that decision and create a different unit that incorporates some of the same lands. And so I'm wondering if you can help me understand where the limits are of your position in terms of deference that's given to former commission orders. And is it your position that you can file for a different spacing unit, including those same lands, a month after the commission has already approved it? Help me understand where the limits are.
Sure. I'd like to back up a little bit and explain that this is done all the time when spacing units are formed. There are often underlying drilling and spacing units that may not have ever been developed or may have vertical development or sometimes horizontal development. And when a new unit is placed over or overlapping that existing drilling and spacing unit, if there's no development, that underlying unit is vacated, and that happens very often. If there is development, for example, a vertical well, oftentimes we maintain that underlying unit for payment of proceeds on that existing well. Same case with a horizontal well. Oftentimes we can maintain, if it's a different formation, that underlying drilling and spacing unit for existing production. In this case, there is no production in the 1920 acre unit. And for that matter, we are asking to vacate that 1920 acre unit. Sections 1 and 12 adjacent to the south of Mallards application lands would then hence be unspaced, and it does not preclude for Dad from coming in and filing a 1280 to develop sections 1 and 12. I think there's no current law or statute on the timing. I think it's under the act, what is the most efficient and economic way to develop the minerals to prevent waste. And if there's a unit that's been sitting there since 2015 and it hasn't been developed, Mallard's plan does create more efficient and economic development and prevents waste by seeking to fully develop from east-west laterals a 960 acre unit.
So what if there was a unit that had been created in January of 2018 and there was no development, and you came in with an application to refinagle those spacing units?
I think if that prior operator has not filed APDs or sought to develop that unit, then there's every right to seek to vacate and respace.
And what if somebody filed one in August? I mean,
sure. And I think, that's not the facts here. So I don't want to kind of go off on a limb here when when we do not have those facts. We have a unit established in 2015, which
I
is
understand.
quite a difference from, a month or two later. But I will say that the Oil and Gas Act mandates that in establishing a unit, again, you have to prevent waste, protect correlative rights, result in efficient and economic development. And so I think if you're comparing older or newly established units and there's a new plan that is more efficient, I think the act would say that you can approve that new spacing order if it complies with those requirements of the act.
And when you say efficient, you're speaking only about the efficiency of taking the minerals out of the ground.
As you've heard, we have engineering witness and testimony that concludes that based on all of the factors we've considered, we will efficiently recover the hydrocarbon resource under those target formations in an efficient manner that doesn't leave any wasted minerals in the ground.
No other questions. Thank you.
Thank you, Commissioner Overturf.
Mr. Chairman,
Yes, Commissioner Holton.
I got a question for you and for the director. And I think you and I have been there since 2011. I don't ever remember vacating an order. Do you?
Director Murphy, I'll defer to her while I think for a moment.
Commissioner Holton.
I mean, this would really open up the books for a lot of, this is a downhill slope big time.
I have a complicated answer, Commissioner Holton, in that as development patterns have changed, especially through, I think, the Jewell and the DJ Basin, there are commission orders that are vacated fairly consistently in almost every spacing application that comes through because those lands have been previously spaced for a different type or style of development. So the fact that Mallard has asked to vacate a spacing order is not particularly unprecedented in my mind. Commissioner Holton, however, I think you're accurate in that we haven't often been in a situation, and it would probably be the first that comes to mind for me, in which an operator wants to keep the existing spacing as it exists, and a second operator would like to change it. So that's the complicated answer.
So if I'm correct, the percentage that Mallard owns is like 5%.
10%.
And the percentage that Verdad owns is how much?
That's roughly 10%, I think, was testified and so I probably shouldn't be answering this, but we'll let Verdad. Yeah.
Commissioner Holton, Verdad owns 100% with its investment partners currently, and in the proposed DSU, we would still own over 2/3.
And Mallard owns.
So you
want to also, Commissioner Holton, you want to know how much Mallard has within the proposed DSU. So we're waiting for them to answer that question again.
Mallard has a factual clarification. The representation of 100% working interest ownership is not accurate. And would I be able to bring up Mr. Madsen to clarify that fact?
What's the percentage of the 1920, of the 1,920 acres, what percentage does Mallard own and Verdad own?
Okay, hold on.
Or control, not own.
It's two different things. So Verdad currently has a 1920 DSU that exists. There's a 960 being proposed, of which we'll ask Mallard, what is your acreage ownership in the proposed 960 DSU?
So Mallard owns approximately 10%.
Correct.
In the proposed 960, section 36 is 100% state minerals interest.
Leased by,
I believe, Verdad, but I would like to clarify that their statement of 100% is not accurate because a lot of that percentage is actually owned by their JV partners and not Verdad itself.
And that's precisely what we said twice. Our investment partners and Verdad have 100%.
I would like to clarify what Verdad actually owns, exclusive of its investment partners.
That's fine. We own 70% outright, 30% by our JV partners, which would also be 50% or more in the proposed DSU, with the remainder being in our investment partners, and the remainder of the disputed 10% maximum by Mallard.
And again, I think we have a factual discrepancy. Mallard's records indicate that Verdad owns 60% and its partners own 40%. So I'd like to clarify the record.
would you care to comment on that?
I'm not sure the commission wants to get bogged down into that, but
Not
I'm
really.
very familiar with the JV relationship, and some places it is 60/40, this one's 70/30.
Also, is there a document or is council just testifying?
I was responding to Commissioner Holton's
I was
question.
not.
Oh, I'm sorry, my apologies.
All right. Commissioner
Well,
Holton.
from what I can see here is that Mallard made an offer to Verdad. Verdad doesn't want to play. And so the reason why we haven't seen some of these orders vacated in the past in front of us in a hearing setting is because everybody agreed to it and then staff went ahead and approved it. Is that correct? That's what's going on here?
Can you say that? Mallard has made it, so Mallard has made an application for an east-west drilling and spacing unit, of which one
Has
section.
Mallard made an offer to Verdad?
Made an offer for what? Sorry, Commissioner Holton.
The lease to vacate the existing orders.
No.
Have the two, has Mallard and Verdad sat at the table and tried to work this thing out?
Yes, I can answer it. That was actually in our testimony. I'm happy to clarify that. The application itself is seeking to vacate underlying undeveloped orders and establish a new 960-acre unit. Mallard's land witness did testify that Mallard and Verdad have tried, or Mallard has tried to conduct outreach to Verdad to settle its protest. This application, as you can see by the docket number, has been pending for quite some time. Each of those outreach sessions has ended in no withdrawal of the protest by Verdad.
So you made an offer to them and they don't accept, right?
I would classify the details of those conversations as confidential settlement communications, but I will say that discussions that did occur between the two parties to resolve this matter.
You made an offer and they did not accept. That's basically what it amounts to. That's not confidential. Not asking for the numbers.
If I may seek to clarify, though, there's not necessarily any sort of offer in the traditional sense of leasing or land exchange or any whatnot, Commissioner.
Yeah, that's Commissioner Holton.
Commissioner Holton, thank you.
Yeah. So as you have two operators with essentially, and I think that's where it gets back to your first question, there's two different drilling and spacing units, and we have had some where we have vacated other units, but typically it's an operator that comes in and vacates their own unit to put something else into place. I don't recall.
Exactly.
Go ahead.
There's no their own unit.
Pardon me?
Our spacing orders don't authorize operatorship, so there is no their own unit.
Okay, sorry. They've applied for a spacing. I'm sorry, I'm not clear about that. Sorry, thank you.
That's fair.
There's been a spacing unit approved by an operator, which then comes back and vacates that spacing unit. That has happened. We've seen that happen a few times. Same operator proposes a different spacing unit.
I cannot say with any
I
confidence it's the same operator in each instance, or if it's not a new operator. It may be.
Could be.
Yeah.
Could be. This, for me, this is somewhat unique. I've seen where we've got two different conflicting. We've got an approved drilling and spacing unit with someone who comes in and asks us to vacate it and put another one in place. Clear as mud?
Okay, I'm done for now.
All right. Other questions, commissioners? I was curious about the, where did I see that? This discussion around their pH being in error. I'm not certain whether this is an apples to apples comparison, but you've got a table, I think it's, in my information, it's Exhibit E1 Mallard, and it's a base number 90 on Mallard General Hearing. That shows your volumetric calculations, and it shows an OOIP of roughly 2.2 million barrels for a Codell for a 1 mile well, and 4.3 million barrels for a 2 mile well. Help me understand how that differentiates from the Codell OIP that Verdad states as being 2.7 million barrels for, looks like to be 1.5 mile well.
So our OOIP is for the entire 640, so 2.1 million barrels in the entire 640. Verdad's OOIP is 2.7 million barrels for just what that particular well scenario is draining, which they are saying there's 8 of them. So if you do the 2.7 times 8, their math says that the Codell OOIP is going to be 16, 17 million. So that's, when you run through all the numbers, that's what that FEH calculation and error does to the oil in place that's in the Codell.
Okay, thank you.
Excuse me, theirs is on a 960s basis,
Correct.
where ours is
The
640, so
right.
not quite 15, probably closer to 11 or 12.
Got that. I just wasn't sure if that was, I just couldn't tell for sure if theirs was for just one well or if that was for the entire 960. It's difficult to understand that. So eventually we'll get them an opportunity to speak to that as well. Okay, I think we are. Yep, case in chief. If there's nothing else, we'll go on to Verdad's case in chief. How much time does Mallard have left?
Mallard has 4 minutes, 53 seconds. Verdad has 19 minutes even.
Okay.
Thank you, Commissioner Benson. I'd like to call Mr. Arthur Beetrell. Mr. Beetrell, could you please introduce yourself and state your position with Verdad?
My name is Arthur Beetrell. I'm the Vice President of Operations for Verdad. I have a Bachelor of Science in Petroleum Engineering from the University of Texas at Austin. I have 12 years of experience in oil and gas upstream operations and evaluation. I've spent the last 4 years of my career working in the DJ Basin for Verdad. I currently manage our operational efforts, including our regulatory team, our environmental health and safety team, our drilling team, our completion team, our production operations team, and our marketing and midstream efforts. I also happen to manage our reservoir engineering and evaluation team that seeks to evaluate and acquire additional assets in the portfolio.
One quick point of order. If we can get Verdad's demonstration up, please. Mr. Beetrell, are you familiar with Mallard's application and docket number 180100076?
I am.
Are you familiar with Verdad's protest to the same docket number?
I am.
I see the. You're looking at Bates number 291. This is the map of the current DSU and the proposed DSU from Mallard. Mr. Beetrell, does this map accurately depict the established drilling and spacing units and Mallard's proposed drilling and spacing unit?
It does.
And do you generally agree with the leasehold ownership figures that we have so far discussed?
I do.
Mr. Beetrell, how many wells is Verdad planning to drill to develop the existing Sonic Star DSU?
The Sonic Star, which encompasses 36, 1, and 12, we have 32 total wells that were applied for in that DSU, and we plan to develop with 16 will be traversing north to south, and 16 will be traversing south to north. Let's go back to that. 2 on the very east of the ones, the 2 on the very east, the ones traversing from south to north will be 2 milers, and the 2 on the very west going from north to south will be 1 milers, so as to minimize the potential waste caused by drilling them all in one fashion, which we can show on the plat a little bit.
And how many wells does Verdad plan to drill in the 320-acre DSU covering the west half of 31?
We have a DSU for 14 total wells, and we probably won't drill quite that many, but somewhere up there.
Mr. Beetrell, is Verdad planning to develop these DSUs together?
We are.
Mr. Beetrell, can you discuss any comments about the lateral length or well economics?
Sure. we've done a lot of extensive planning, developed both these units. We saw these units when we originally acquired the assets from Carrizo as highly important and got a significant amount of allocation of value during that acquisition. We have surface locations, and we've also arranged midstream contracts that we have in place today with existing infrastructure in place that's currently being built, and we plan to pipe all fresh water, produced water, gas, and oil out of these locations ultimately. The lateral links, as I mentioned, are, can we pull those plats up by chance? There we go. So as stated, we've adjusted the configuration of the unit. These are the ones these are PEGI wells coming from north to south, the 2 westerly wells, to try and minimize that section offset. Ultimately will be 1 milers followed by the 1.5 milers going down. And then likewise, the other half of the unit on the next slide, please. We'll have two milers going on the very eastern side of it, going up there to minimize the potential for waste ultimately on the east side of the unit as well. We've done a lot of analog analysis, very similar to our Mallard counterparts, and it's the actual impressive economics of the area, which is why it's been very hard to come to a resolution on a potential deal with them. We have been in discussions with them. We have tried to have a resolution there, but inevitably the bid is a little too far from the ask, and that happens. And so that's why we're here today.
You heard some descriptions about the shape or the cylindrical nature of the well. Can you comment on that?
Yeah, I mean, I think that Mallard is, to your point, ultimately they just assume that it's a perfect cylinder that they're draining, and that's why they have equivalent probably height and width of their drainage. I'm not saying that that's inaccurate or anything like that, but I think that's what y'all were trying to get to earlier. I also think that they can talk about our pH, which was stipulated, and I agree to that. But inevitably, the CODEL is very difficult to evaluate volumetrically. There's a lot of shoulder effect happening on it, so that affects dramatically your ability to calculate oil saturation and pH for that matter, because of the fact that the tools that you're measuring the formation are actually longer than the formation itself. And so you get formation bedding, you get shoulder bedding effects on it, makes it very difficult. We said 5.5. It may be bigger than that, could be smaller than that. But I would kind of dispute a 28% recovery factor. And I would also dispute a 70% oil saturation that they used in their analysis. So I think it's kind of a tit for tat situation we're in ultimately.
And to clarify, has Verdad submitted APDs for both these DSUs?
We've submitted APDs. The current Sonic Star APDs are pending. They're the ones traversing from south to north. We submitted our PEGI APDs in shortly thereafter. One of the issues, and then we've also submitted our potassium feds, which are the existing 320-acre unit in 31 to the east. We submitted all those. They were rejected. The ones that were overlapping with Mallard's permits were rejected ultimately. And it should be noted that we were in a discrepancy earlier with the commissioners, or excuse me, with the director, in a situation where we were under contract to buy the assets themselves, and we tried to permit, and we certainly would have permitted these wells well before if we had that opportunity, but we simply didn't have record title to the assets at the time. We didn't close on the acquisition with Carrizo. We didn't have record title to the interest until January 19th of 18. We filed our permits within a month to a month and a half thereafter. And so we thought that was pretty timely and also reasonably prudent operator standard ultimately.
Mr. Buttrell, what is Verdad's anticipated timeline for developing the Sonic Star DSU?
We have to be expedient. Our state lease in 36, in section 36, actually expires in the summer of 2019. And that's one of our largest concerns here ultimately, is that if this DSU were vacated ultimately, it could potentially open us up to irreparable harm, whereby Mallard potentially delays or development is delayed because they're federal APDs, and therefore thereby our lease could theoretically expire before we were able to develop it. So it's critical to us to keep these DSUs in place so that we can go out and develop in the early part of 19.
Lastly, Mr. Beecher, in your opinion, will Verdad's drilling plans prevent waste, protect relative rights, and economically and efficiently develop both the Sonic Star DSU and the 320-acre DSU, that's the west half of 31?
We do. We think the Carrizo went through a tremendous amount of technical analysis. They did rate transient analysis where they went in and monitored offset wells. So while Mr. Volkmer can say that he thinks it looks a little fishy, I don't have the data. I looked for it. I went and asked for it. They boxed it up and sent it to a storage unit. I was not able to get it. I wanted it for this purpose ultimately. But at the end of the day, they've gone in and done rate transient analysis to try and prove that these setbacks are needed ultimately here. We actually are seeing this in a lot of other places because 600 may be a little too big. And so we want to go a little bit smaller. We think that Carrizo set a precedent with the original DSUs that 300s were okay and protected the correlative rights of the offset owners.
Commissioner Benson, hearing no objections, I'd like to enter this testimony to the record.
Thank you very much. Is this your only witness?
I have one more.
Okay, I think we did the cross before. I think you waited until both of their
Okay, I'm going to call my next witness now.
Is that all right? I think we'll be consistent if you don't mind, Ms. Wozniacki.
Sure, I just have a couple questions, so I can wait.
We'll call him back.
I'd like to call Frederick Rowe. Mr. Rowe, could you please introduce yourself, state your position with Verdad?
Yes, my name is Frederick Rowe. I am the land manager for Verdad. I've been land manager for Verdad since 2013 when it began its operations in Colorado. Previous to that, I have 10 years total experience in land, and before that, I was had completed my military obligation, where I was a cryptologic linguist in the United States Air Force. Served honorably for 8 years.
Thank you, Mr. Rowe. And are you familiar with Verdad's application and docket number 1801-00076?
Yes.
Are you familiar with Verdad's protest to the same docket number?
Yes.
Going back to Bates number 291. Does this map accurately depict the established drilling and spacing units and Mallard's proposed drilling and spacing unit?
It's not on the right slide, but
oh, sorry.
Yes, it
A
does.
little too fast there. Will you please describe or point out to the commissioners the established drilling and spacing units in that area?
Yes, on the far west of the map, you have our 3-section unit, which is comprised of section 36, which is state lease, and section 1 and 12, and then the northeast quarter of section 13. And those are the BLM leases. To the east of 36 and 31, you've got the west half of 31, which is the other spacing unit.
So, Mr. Rowe, section 36 and the west half of section 31 are currently within established drilling and spacing units.
It's not an established, that's what we're discussing today.
They're correct, but they're currently in these orders that are on this map.
Correct.
Mr. Rowe, does Verdad own leasehold in section 36 and the west half of section 31?
Yes, we do.
Mr. Rowe, what percentage of the leasehold does Verdad own in those units?
Verdad and its investment partners in 36 own 100%. In section 31, we own over 18% in the west half of 31.
And Mr. Rowe, what proportion does Verdad own in Mallard's proposed DSU?
It would be over 2/3.
With your investment partners?
Yes.
And on your own, at least a majority owner?
Yes, those investment partners are JOA bound, and they've named us as the operator.
And does Verdad own leasehold adjacent to Mallard's proposed DSU?
Yes.
Mr. Rowe, Verdad owns state and federal leasehold interests. Can you describe briefly those leases?
Yes, the lease with the state is section 36. It encompasses the entire section. And then the lease with the BLM is section 1 and 12. And that also includes the northeast quarter of 13, which is shown on the map.
Mr. Rowe, the Sonic Star DSU is subject to both state and federal communitization agreements. Could you please describe what those are?
Yes, a communitization agreement is an agreement between the government authority and any adjacent parties or parties included in the spacing unit to associate and assign who owns what and what will be paid when oil is sold or gas.
So, Mr. Rowe, to your knowledge, the BLM and the State Land Board for their respective CAs actually conduct their own independent analysis and will offer even their thoughts on these communitization agreements.
Yes, they do. It's an involved process. It's slightly different between the two parties, but yes, they're very involved.
This is Bates number 295. And Mr. Rowe, can you describe this exhibit, please?
Yes, this exhibit shows Verdad's surface use agreements that it plans on drilling from. On the north, the small red square is where we plan on drilling our Peggy wells from. I'd also like to note that the northeast quarter of the northeast quarter in section 36, which is not labeled, is also where we have secured a surface use agreement with the state, which is again an involved process. The red square on the far southwest of the map is where we plan on drilling the Sonic Star wells that are going to go from south to north.
And that Sonic Star surface location appears to be off of the lease. Can you tell us why?
Yes, it's off the lease because the section 1 and 12 are in the Pawnee grasslands, which are considered sensitive areas, and we have a no surface occupancy lease there. So we had gone in and worked diligently to obtain a surface use offsite, which would allow us to develop this lease.
And can you describe any archaeological surveys or any other processes that go into the BLM's analysis of this no surface occupancy designation?
I'm not a regulatory expert, but I do know that we have engaged firms that have helped us through this process, and it's ongoing.
What kind of time or resources involved with those processes?
It is not quick, and it's not inexpensive either. It's these are specialized regulatory firms that's all they do.
Wrapping up, Mr. Rowe, has Verdad participated in settlement negotiations with Mallard?
Yes, we have had multiple in-person talks with them and have failed to reach a resolution.
And in your opinion and in your involvement, has Verdad attempted to resolve this dispute in good faith?
Yes.
And no further questions, and hearing no objection, I will request this testimony be entered into the record.
Thank you very much. Are you prepared for some cross?
I do just have a couple questions. I can start with Mr. Rowe if that's easier. Mr. Rowe, the investment partners that you've alluded to in your testimony, they're independent partners, is that correct?
Yes, they are independent.
Thank you. That's my only question for you.
Thank you, Mr. Rowe.
I do have a couple questions for Mr. Beetrell.
Okay.
Mr. Beetrell, Mallard's application was filed on November 30th of 2017, is that correct?
I believe that's correct, yeah.
And Mallard's APDs were filed in December of 2017, is that correct?
I think that's what's been alluded to here today.
Thank you. And you closed the deal with Carrizo in February of 2018 per your testimony, is that correct?
No, mid-January.
Okay, and it closed in mid-January?
Correct.
Okay, so when you closed the deal with Carrizo, you closed with the full knowledge of Mallard's application and APDs, is that correct?
We absolutely did, yes.
Okay, thank you. I believe that's the only question I have for you. Thank you.
If I could, one question redirect.
Certainly.
And because of your knowledge of Mallard's application, is that what led you to hastily, or as quickly as possible, put together your permits once the deal was done with Carrizo? You didn't waste any
because of
time.
the permits, because it's some of the most economic locations we have. I mean, we want to drill them. I mean, that's why we want to permit these wells and go out and execute them. It's not just because they had their permits there, et cetera, et cetera, et cetera. It's an economic resource that we would like to go out and exploit, and that's what matters to us at the end of the day. And it was part of the investment thesis with buying Carrizo's assets here.
Thank you, Mr. Beetrell. Nothing further.
Very well. Commissioners, some questions? Yes, Commissioner Hawkins.
So if Verdad drills their north-south patterns on section 36 and 1 and 12, what are your plans for the west half of 31?
We actually already submitted permits there as well, called our Potasnik Feds. And so we actually have a location just to the north of that half section in section 30, the southwest quarter of section 30. And so we've already secured that, and we had submitted permits there as well. And so we would go develop that as well. I mean, this is all in the same area where we're going to be running infrastructure lines and things of that nature. So it would be included in that drilling forecast.
That's a 320-acre spacing unit?
Correct.
And it'd be north-south, 1 mile lateral?
Yes, sir.
Okay.
Yes, sir.
How many wells are you looking at? Is that like?
It would roughly be half of what we're doing for a half section, so 8 wells.
8.
Yes.
And if the spacing unit were vacated and Mallard developed 31 and 36 or in an east-west direction, how would you develop the north half of 1?
Well, we would have to extend our wells to 2 milers like they had mentioned ultimately.
And is that, you have an opinion on whether that's more or less attractive or
I would say that,
efficient?
I would say based on the analog results in the area, whether it's a 1 miler, a 1.5 mile well, or a 2 mile well, they're all highly compelling. We are a little bit agnostic to the lateral length at this point because we think that they're all economic return scenarios ultimately.
So there's really not an economic, assuming all things being equal, there's not a preferred development method that's going to recover more or less than the other, is what I'm seeing.
The only diminishing economic potential would be due to the fact that Mallard has applied for a 600-foot setback, and thereby they may not appropriately drain the resource like we have shown ultimately.
And then what is the setback currently set at?
It's at 300 right
300.
now. Yes, sir.
Other questions? I had one about your economics. And dates number, I believe, 301 and 302. Were those developed based on the production forecasts that were used to that? Were those developed on a type curve analysis or your oil in place calculations?
These were developed off of a type curve analysis ultimately.
And what type curve did you use? Did you use the ones that were in the exhibit? The old Carrizo ones?
No, we did not. We built our own actually.
Okay. And what group of wells, sort of where did you reach out?
I believe they're in the exhibit just above that. They're listed.
Okay, so that's all the wells? Sorry.
Yes, sir. Yes, sir.
Used?
Yes, sir.
Okay, thank you. All right.
If I may, 299 and 300 on the base numbers.
Yeah, so 299 and 300 were your wells that used in type
Yes,
curve.
sir.
And sort of how far away, just can you?
I would say that
speculate
the
on
geographical extent is a little bit less than Mallards ultimately. They went down and got wells that were down in 860 and 861. We were focusing predominantly in this area of interest right here. And so I would say maybe a little bit more geographically local to the current DSU.
And a variety of horizontal wells, I presume?
Absolutely, all normalized for lateral length and trying to actually use current vintage wells. So most of these wells are going to be probably 2016 or later ultimately.
Okay. Thank you. Commissioners, other questions? All right. How's our time, Ms. Bryan?
I have Mallard with 338 remaining, Verdad with 221 remaining.
Okay. There's this in here presentation on any 510 statements. Did we receive any 510 statements on this matter? So, okay. Thank you. Next one is staff analysis. You look so excited.
Is that the same thing as hearing officer recommendation?
Something along that line, yeah.
That's exactly what it is.
Thank you, Commissioner Holton. I guess I would have to come down on leaving the existing units the way they are and drilling those existing units for these reasons. One is administrative certainty. In spite of the argument by Mallard that the units were established in 2015, it was in 2017 that the Codell was added, and that's the effective unit that we're dealing with now. You have a 600-foot setback on the bottom of section 36 and a 300-foot setback on section 1. You're looking at 900 feet of minerals that will not be developed under the Mallard scenario. Whereas under the Carrizo scenario, if you have 150-foot setbacks between wells, that's all that's not going to be developed. I think that's a compelling reason to leave it the way it is.
Very well. Short, succinct. Any other questions? We'll proceed ahead unless we have any other questions for the hearing officer. I believe the next item is a rebuttal by Mallard.
I'd like to reserve our time for closing statements.
Verdad?
Same here. Thank you.
Well, then you may proceed with your closing statement.
Thank you. So Verdad started this hearing by classifying Mallards Application as a land grab, which is a misclassification of what's going on here. Verdad has simply not developed its leasehold interest since the unit was first established in 2015. And yes, the Codell formation was added in 2017, but that leasehold interest has been established for quite some time now, and the unit has been established for many years. Verdad took the risk when it acquired its interest from Carrizo, knowing full well in record title that Mallard had filed the drilling and spacing unit application and filed the APDs to develop its unit. So Verdad did take that risk. It sat on its leasehold and nothing's been developed. Meanwhile, Mallard is actively drilling the unit adjacent to the east of this drilling and spacing unit. It already has 2 pad locations. It has pipeline infrastructure. It's proposing 3 sections of methodical development that will leave no waste. An east-west orientation, as I explained, is a preferable recovery when you look at the irregular section lines. Verdad's own testimony admitted that to deal with the section line gap, they have to drill a 1-mile lateral on one side. And they've also admitted that 2-mile laterals in sections 1 and 12 are economic. So I think everyone can win here in that Verdad can develop a 1,280 acre unit, north-south. It definitely, complies with the irregular section line boundaries. And they just admitted in their own testimony, and they filed 2-mile APDs, that a 2-mile unit is indeed economic. At the same time, Mallard can use its 2 pad locations, its infrastructure, and it can develop its economic 16 wells in an approved 960 acre, 2 adjacent 960 acre units. And so I think when you look at this as a whole, and if you look at what's been approved and permitted, both within and adjacent to Mallard's application lands, Mallard has simply the better development plan. Mallard is committed also to seek reduced setbacks. I think it's been stated that 600-foot setbacks may leave some waste and be inefficient and uneconomic. And Mallard testified today that it once the unit is established, it will come and seek reduced setbacks, possibly as early as December hearing. So I think that's something that Mallard acknowledges and is willing to agree on. So with that, I would ask you to evaluate the testimony today and approve Mallard's application for a 960-acre unit for the efficient and economic development of the application lands. It prevents waste, it protects correlative rights. We're asking you to approve 16 new horizontal wells and to deny Verdad's protest. Thank you.
Well,
Commissioners, thank you for your time today. Getting close to the end here. The APD is not the sine qua non of development. It's just not. Development means a lot more. That's why respectable oil and gas companies, like both of these are, have many highly educated professionals to handle the land, the drilling, the business development. All these pieces go into development. It's not just the APD. So I ask you to remember two things. The one, promote administrative certainty. You'll be reminded that the last edition, the edition of the Codell was in May 2017. That is the effective target formation. Only 6 months later, just 6 months later, 1/4 of the time, the life of an APD. It's not enough time to develop. But yet still, Verdad and its predecessor Carrizo were putting those resources, that time, that energy to do things right. That is the reasonably prudent operator. You reviewed Sonic Star. You reviewed West Half of 31. You verified all the details. You took the diligent time of your hearings officers, your staff, and your own time to make sure that was done rightly. All we're asking you to do is simply maintain that. My client is ready to drill now that all the preparatory development has been done. Secondly, I'm asking you to prevent the rush and recklessness that can come about by this idea that you're choosing a winner when there's already someone at the starting line. We've done everything right. We have reached out with BLM, the State Land Board. Oh, they're not rubber stamps either. The term was not used, but to insinuate perhaps that a communitization agreement is something that, oh, just gets approved because the order comes from you first. No, they're real engaged partners in these units. And I think by seeing the federal CA renewed in July shows just that. I think it's presumptive to be told that we can just be a winner by reducing our own units and not taking into account all of this productive development work we've done so far. 10% ownership max, a minority interest to kick out 100% with our investment partners, fine. 70% clearly on our own, not only in Sonic Star, but also at least the majority owner of the proposed DSU. Just makes no sense. This is not a race. You demand things to be done right, and so does my client. So please take this into account and deny Mallard's application. Thank you for your time today.
all right. Before we close the record, any other questions? I had one that I was sort of struggling with, and I may have missed this. In your exhibits, did you provide us with a type curve? I may have missed that somewhere.
Yes, it's in the volumetric copy. 1 mile UR, which is 50.
So that's your type curve result, and that I see Bates number 90. Is it E1? I'm sorry?
I see Bates 93.
Bates 93. All right. May have missed that.
Exhibit 21.
Oh, the type curve, yeah, which just, it's a couple of curves, but there's no numbers on it.
Okay.
Yeah. And some data, I was just looking at the hard data. And this, with that, an estimate of gas recovery. You've got oil on that, on the table on Bates 90, but I didn't see anything for gas.
Right, there's a gas recovery behind this, but also in the reservoir, you're dealing with oil, and you don't have flash gas until you drop the pressure to the surface. So
I sort of get that, yeah.
When we're looking at the drainage, the overlap of drainage in the reservoir, we're looking at it from an oil perspective. So all all of the gas and the NGL type curve is all behind this, but
So these are then technically these are reservoir barrels, not stock tank barrels.
it's converted to stock tank barrels.
Oh, it is. So
Yes.
if you convert to stock tank barrels, wouldn't you want to show the associated gas with the stock tank barrels?
For the purposes of drainage in the reservoir, as it equates to barrels at the surface, I didn't do it here.
All right, thank you. Sure. Any other questions? Are we prepared to close the record?
Before we close, I have one request. Ms. Prine, if I have any additional time, I just have one further point to make. Would you mind if I make one additional point?
Go right ahead.
Thank you. Thank you. I just wanted to address Commissioner Holton's comments on the vacating a drilling and spacing unit. I hope we didn't get lost in those. And it is common practice. You'll find multiple spacing applications on your consent agenda likely today that vacate underlying drilling and spacing units by that operator or other operators when they're undeveloped. So I do just want to clarify that it may not come before you, but it does happen frequently. Thank you.
If I could reply.
Might have happen frequently under the consent agenda, but it does not happen by protesting.
Right. So we better find out how much time you have.
Yes, sir. Ms. Prine, if I may.
Verdad has 0 seconds left.
Sorry. I have a question for the director. If we proceed and follow notionally what the hearing officer has recommended, what will happen with respect to the rejected APDs? And that's on the Peggy wells.
If
then they would then become part of an approved TSU.
a rejected APD would have to be resubmitted.
You'd have to resubmit those.
We've actually already submitted them, and they're just sitting in draft per the commission staff right now.
So they're not really rejected.
Yes.
What
Commissioner
about the existing APDs that have been submitted for the
Mallard wells.
Mallard wells?
For APDs to be approved, they need to match the spacing configuration for those lands. And so if there is a problem with that, i.e. if the submitted APDs that are under review or in process don't match what the spacing unit matches, they will be rejected.
Very well. Are we ready to close the record now? Seeing no disagreement, we shall close the record and begin our deliberations. Who would like to stand in for Commissioner Boygan this time? Commissioner Hawkins.
Well, I'll start with at least my analysis of this. We have spacing units that the commission has reviewed. We've had hearings, we've approved, and I agree that we have in the past vacated old spacing units that may need to be changed because we see a better development approach from what was approved in the past. Today, I didn't see anything that looks any better than what's already been approved. The lands appear to me they're going to be fully developed with horizontal development. In fact, there may be less acreage left undeveloped if we stay with the old Verdad spacing unit and the 300-foot setbacks. So I don't really see a compelling reason to vacate the spacing unit. Typically what we've seen in the past is you had a bunch of wells that were, or spacing units that were created for vertical wells, and then all that got vacated so that we could put horizontal development with 1 mile to 2 mile laterals. And so we needed to change the way the spacing units were configured. I don't really see that happening here. And I do think that an operator who has significant working interest in these spacing units that's going to be diminished by some other new operator coming in and try to with 10% takeover operatorship, doesn't seem to make a lot of sense to me. So I'm in support of the staff's recommendation to deny the respacing.
Very well. Commissioner Egger.
I agree with Commissioner Hawkins. I think we're back to operators presenting technical experts who say my plan's better than this plan, and they tell us why they're protecting correlative rights, why they're preventing waste, why not drilling unnecessary wells, and why the other operator is. And we're back to this commission trying to sort out which one's better or not. And in a lot of ways, we're not necessarily qualified to do that. I think that our staff did look at these old spacing units and approve them, and we have to trust that. And so I'm also, I hear that I think in the past we've set a little bit of a precedent saying, oh, well, people or operators, this operator looks like they're going to drill. It's more likely they're going to drill soon. And I think we've seen both of these operators are ready in different ways, maybe with APDs, maybe with surface agreements, but they both made effort to develop these minerals. And so it's really hard to try to split hairs and say exactly which one's a better plan in an hour and a half and maybe a half hour of testimony. And so I think we have to kind of go back and rely on what was already approved, and this administrative certainty, which is an odd term and probably means a lot less than we want it to mean. But the one thing I also want to consider is that I think we do see, based on our past practices, we see operators filing APDs as quickly as possible. And I think it's tying up our staff. And the one thing I don't like is how much time has staff spent looking at APDs that are on record right now without the drilling and spacing unit. And that work might not even have been necessary. And so I think that's another issue that we can't solve right now, but we have to consider as we move forward. And we're probably going to talk about it tomorrow and probably at the next hearings as well. But right now, I tend to agree with Commissioner Hawkins.
Mr. Jolly.
I would concur with the comments that Commissioner Hawkins and Hager just made. Also, I think that I don't want to do anything that's going to encourage competing APDs. The commission has enough going on without encouraging this. I think the Verdad has taken a regional balanced approach or responsible approach to getting their ducks in a row. No pun on words are intended, Mallory. And I just, I guess I know spacings do get changed, but it's by concurrence before, it doesn't have to reach commission hearing level usually to take away a spacing. Generally, these operators get it done by negotiation, not there's a threat of a hearing here. So inclined to stick with Verdad's plan.
Very well. Any other comments from any other commissioners? Commissioner Holton, anything that you'd like to add?
No, I agree with everything that the rest of the commissioners have said. I also want to encourage the commissioners to take staff recommendations. I mean, they're the ones that spend all the time doing this, and they're not right all the time, but 99% of the time they are right. And so I think we need to take their recommendations under consideration seriously.
May I?
Yes.
Mr. Chair?
Commissioner Overturf.
So I also will be voting to deny the application. I think this is really opening a Pandora's box, this idea that we're going to be vacating existing spacing units under circumstances like this, under these unique types of circumstances. And I strongly object to the statement that the standard that we should be utilizing here is which of these applications is better. that places them on an even footing that I think is unwarranted. I think there needs to be a showing of significant change in circumstances in order for us to go back and change an existing spacing unit under circumstances such as this. I think pointing out inadequacies in the initial application in no way meets that standard, because the fact of the matter is that Mallard did not protest the initial spacing application. The appropriate remedy for them, if they thought the commission had really screwed up and done something wrong in creating the initial spacing application, would have been to appeal that decision, to participate in that proceeding, and yet they did not do so. I think this is an attempt to wage collateral attacks on prior commission decisions, which could throw our proceedings and our docket even more into chaos. And so that's why I will be voting to deny the application.
Very well. Mr. McGowan? Okay. I mean, nothing more to add. So perhaps Commissioner Holton would like to make a motion.
I move that we deny the application.
Seconded by Commissioner Hawkins. Motion made by Commissioner Holton to deny the application. Any discussion? Are we ready to vote? Very well. All in favor of denying the application, please signify by saying aye.
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 Opposed, same sign. Hearing none, the motion carries. The application is denied. Thank you all for an entertaining afternoon. I believe that is all we have for today. Yes, Director.
That's true, Chair. I did receive an update on the Swan pad.
Okay.
If you want to take a couple minutes to hear it now, if you want
Sure.
to start tomorrow morning with that. So forgive me, I have a very thoughtful email from our technical staff. So I want to try to make sure I don't delve too far into the details, but staff rejected the 2A on July 31st of 2018. Staff does expect that the operator will resubmit the application when the operator is ready. The Form 2 APD or the drilling permit remains on hold presently. And I presume that's because there's not a pending surface use permit that would allow the APD to be reviewed and approved. For the 2A that has been rejected, COGCC received approximately 50 public comments. So I hope that gives you comfort that the folks that are coming and talking to you are also communicating with our staff in great detail about their concerns. From what our staff gleaned about the Arapahoe County status, Arapahoe County approved a USR for the location, and the location being the one that's driving the controversy as opposed to the neighboring location to the Caddy Corner proposed by on Mr. Lang's property on August 28th, and the county imposed 16 conditions of approval. Emergency egress is addressed through the local process, and Arapahoe County has included a condition of approval for a northern egress route, which would provide an alternative means for residents of Watkins Farms to evacuate if deemed necessary in the event of an incident. The operator obtained a will serve notice from the local fire department, and we'll have to re-up that letter if they add wells. I don't actually know what that means, but I'll try to figure it out if you have follow-up questions about it. I know that the fire department has been engaged and has submitted correspondence that either to COGCC or that staff has received about this application. And the fire department does consider public safety and egress in their decision to issue the will serve letter. So I guess I infer that this is the letter that I think of as meaning the fire department was okay with the plan. So our staff has not been made aware of the alternative available location, i.e. the Lang property. And so I've committed to bring this letter back to our staff so that they're aware of it and can consider it. So that's obviously the Lang property may be convenient from a surface perspective, but it may create downhole or mineral ownership concerns. And those would be things that we would certainly have to take into consideration. So I think that's about the scope of the information that I have at this point in time. If you have further questions, I'm happy to try to answer them now or actually get complete answers to them.
Sorry. I have a question, but I'll wait.
Does this mean no staff decisions until you can circle back with us on how things have progressed and whether or not that alternative property is actually a viable alternative?
Right now, staff does not have a pending permit to review. So, however, if as staff anticipates, a permit is resubmitted to staff, there is not a context in which staff brings 2As to this commission.
Mr. Ager?
What is a USR?
Use by special review.
I'm so sorry. It's
From
the
the
land use
county.
approval from the county.
Oh, use by special review.
Okay, and can you tell us why the permit was rejected?
My notes say technical reasons, which means we have a rejection policy that means numbers don't match up or a permit doesn't match the spacing application, something fairly superficial that should have been caught.
Okay, thanks.
I missed this was Swan. I'm
Yep.
sorry.
Yeah, I missed the first part of that.
This was the Swan, this was about the Swan one, which we asked the question about because of the Lang, the letter from the Lang about a proposed potential alternative. Commissioner Jolly had asked about what was the surface location that had been approved locally through the use by special review. And the comment was that it was the one that was in the Form 2A apparently, so not the new one. So then what I heard is that you're going to try and connect the dots, provide the Lang letter to our staff. My question being is that we've heard a lot of public comment about that. Is that, are those folks that are coming to us and commenting on it, are they aware that it's actually Arapahoe County that is involved in determining to some extent what that surface location is?
That's a great question, Chair Benton. I don't have a precise answer for it. I'm aware that there's been a very active dialogue in Arapahoe County around oil and gas development. And from that awareness, I presume that these folks are as engaged with their county as they are with us.
Sure hope so. Does that help? Do we entertain a motion to adjourn?
Mr.
Until
Chair.
9 a.m. tomorrow. Yes, sorry.
Before we forget, and you may have just reminded of this, tomorrow morning for breakfast here at 7:30, you are meeting with some of the local elected and appointed officials.
Very well.
Please do not forget.
Okay. Now we'll entertain a motion to adjourn.
So moved, yeah, second.
Okay, moved and seconded. All in favor, say
Wait,
aye.
hold on.
Wait. Oh, okay. Discussion.
I want to clarify that for purposes of what is actually a meeting and what is not a meeting, tomorrow morning, 7:30 breakfast is a social event.
That's right.
Correct.
It is, and
Okay.
it is been by invitation to the local elected and appointed officials so that they can meet with you. It is not a public event, although the doors will be open if the public shows up, but we will not have enough breakfast if the public shows up. So that is my clarifier.
Thank you.
No, it's a great opportunity to meet with some of the local officials and who are involved in this on the ground level for oil and gas development. And they hear a lot of the folks that come and talk to us, come and talk to them as well. So it's an opportunity to thank them for a lot of their hard work here locally.
So we need a motion to adjourn until 9 a.m. tomorrow when the commission
that was
meets
what
to
was
conduct
made.
this business. Okay.
The motion was made to adjourn until 9 a.m. tomorrow.
Okay.
And seconded. All in favor, say aye. Aye. Opposed, same sign.
I'm sorry, Mr. Chair, who, I have the motion
Motion was
from
made, I
Commissioner
believe, by
McGowan
Commissioner McGowan.
and seconded by
Commissioner Hawkins.
Thank you.
Sorry.
Sometimes
It
it's
was more.
you just
So
gotta
I had,
sit with
I
what
wasn't going to drag this out,
You're funny.
but these dudes did not do the technical analysis. They sort of poked at him a little bit.